In this area, we're going to talk about the Chapter 2, the New Economy, Revisioning Work. One of the cases that you'll read about is Patrick Cotter versus Lyft. Patrick Cotter was a Lyft driver for roughly 4 months, during which time he gave 173 rides, which covered about 410 miles. He arranged his driving schedule so that it would not conflict with his work at that time for Facebook. Cotter was terminated after giving rides in a vehicle that had not been approved by Lyft. He and other workers sued Lyft, arguing that because the company misclassifies its drivers as independent contractors, they had been deprived of protections that California law provided employees, including the state minimum wage and reimbursement for work-related expenses. Could plaintiffs be declared employees as a matter of law? That means, would the court rule as a matter of law that the plaintiffs in this case, the Lyft drivers, were employees? The court holding was no, the court could not declare as a matter of law. There were facts that supported possibly independent contractors and also facts that supported employees. So the court held in this case that this was a jury question for the jury to decide. So one of the things that you're going to be looking at in this second chapter is whether the employees are independent contractors that do not have the same benefits as employees, or whether they're employees that have more benefits that the employer is responsible for than would be an independent contractor. Another act or law that you're going to be looking at is the Fair Labor Standards Act, and this sets the national minimum wage for those covered by the law and requires employers to pay time and time and a half wages for work more than the maximum hours, which usually is about 40 hours per week. Now, not every employee or worker is covered. For example, the law exempts white-collar workers, executives, administratives, professionals, computer, and outside salespersons who earn a certain minimum salary from the overtime pay. So, for example, I teach at A&T. I would not be considered to be covered under this Fair Labor Standards Act. In Goldberg versus Whitaker House Cooperative, the Supreme Court stated that the ultimate test for classifying workers under the FLSA should be an economic reality rather than focusing on technical concepts. So this Supreme Court case concluded that workers are regimented under one organization, doing what the organization desires and receiving the compensation the organization dictates. They are employees under the FLSA. And they said specifically, under our approach, the more regimented the workplace, the more an individual is likely to be characterized as an employee. The more a worker retains flexibility as to the working relationship itself, the more the worker is likely to be characterized as an independent contractor. There's also the National Labor Relations Act, which you'll read about and learn about, which protects employees' rights to organize and bargain collectively. It's enforced by the NLRB, or the National Labor Relations Board, which is an independent federal agency empowered to safeguard employees' rights to organize and decide whether they will be represented by a union. And again, not all workers are protected by the NLRA. Agricultural laborers are not protected. Domestic service workers and independent contractors and those that are classified specifically as supervisors are excluded from the protection of the NLRA. There has been a decline of the corporation, and you're going to look at Nike, for example. Nike has demonstrated that design and production could be organizationally separated. The company had the design being done, for example, in marketing in Oregon, while other companies in China or Indonesia or Vietnam could handle manufacturing. And still other companies could manage distribution. This was the Nikeification, a new model of post-industrial organization. The next stage in this evolution after Nikeification is Uberization, which is renting labor for specific tasks rather than hiring for jobs. And business authors in the 1990s published many Tomes on the death of the career, arguing that companies no longer valued long-term employment and that smart workers were perpetual free agents, always on the prowl for the next opportunity. The job had replaced the career. This is referred to as the gig economy. So opportunities for limited employment, sometimes referred to as gigs, have existed for decades in certain industries like music and entertainment industry. They have been likened to the widespread small-scale self-employment typical of the pre-union and pre-industrial eras. What is new about the gig work today is that it is often made possible by technology, which frees workers from the need to travel to the employer's workplace and allow them to work multiple jobs at once. This offers workers and perhaps even managers a new set of advantages and disadvantages in the employment equation. The gig economy is an environment in which individuals and businesses contract with independent workers for short-term assignments, engagements, or projects offering few or no benefits beyond compensation. A freelancer or a contractor is a self-employed worker who may work with more than one client, but who usually has a contract that covers the details of the job, including compensation. The terms freelancer and contractor are generally used interchangeably. However, if there is a distinction, it is that the freelancer is almost always self-employed and works for multiple companies, whereas a contractor may or may not be self-employed and may work for only one company at a time. Some may be happily committed to their independent status, and others are involuntarily self-employed while they search for more permanent or full-time positions. Gigs might be full or part-time. They might be limited to a specific task or a specific time, and they may serve as the worker's sole employment or as what's called a moonlighting job. In addition to gigs, what we also see is telecommuting. And this term emerged in the 1970s to describe the practice of working at a specific location, whether the employee's home or an alternate office, to reduce commuting time to a centrally located office space or store. Telework was greatly facilitated by the new telecommunication technology, including internet, email, and mobile phones. Today, commuting means any mode of work at a remote location, home, or other space by virtue of electronic connection and or telephone, and encompasses a variety of employment types, from gig assignments to part-time contract work to traditional full-time employment. Respondent superior. Under this doctrine of respondent superior, an employer may be held liable for the acts of his employees committed within the scope of their employment. A claim for vicarious liability under respondent superior theory consists of two prongs: an employee-employer relationship and also a tortious act committed by the employee within the scope of his employment. So the concept of imposing liability for the fault of another is known as vicarious liability. The rule of law imposing vicarious liability on an innocent employer for the wrongdoing of an employee is also, again, as I stated earlier, is known as the doctrine of respondent superior. In modern times, this doctrine can be justified on the grounds that the business should pay for the harm caused in the doing of the business, that the employer will be more careful in the selection of employees if made responsible for their action, and that the employer may obtain limited insurance to protect against claims of third persons. So an example of respondent superior would be if I am driving and I'm hit by a Frito-Lay truck that is delivering some of the products. That is done within the Frito-Lay truck driver is delivering or working. He hit me within the scope of employment. So I could sue not only the driver, but also Frito-Lay, and Frito-Lay will be held vicarious liability under this doctrine of respondent superior. So this is a really good chapter. Enjoy exploring. Let me know if you have any questions.